In a nation where the gavel wields more silence than justice and power often wears a robe, few expected the most earth-shaking political moment of the year to unfold during what was expected to be a routine congressional hearing on judicial ethics. But sometimes, history doesn't give warnings. It just erupts. And this particular eruption began with the subtle creak of a door and the quiet entrance of Supreme Court Chief Justice John Roberts, a man whose very presence can recalibrate the gravity of a room. Dignified, precise, and deeply aware of his institutional legacy, Roberts stepped into the chamber believing, perhaps with some justification, that he was untouchable. But what he did not know, what no one in that room could have predicted, was that across from him sat a woman who would not only challenge his authority, but would also unravel the illusion of invincibility that often cloaks America's highest court. That woman was Congresswoman Jasmine Crockett. Relatively new to Congress, but by no means new to confrontation, Crockett brought with her the fire of grassroots activism, the precision of a seasoned civil rights attorney, and the tenacity of someone who had spent her career standing up to entrenched systems of power. Raised in Missouri, trained in the courtroom trenches of Texas, and armed with a legal mind sharp enough to cut through centuries of judicial tradition, she was not there to perform. She was there to hold the most powerful man in American law accountable. The hearing began, as such hearings do, with formalities. Statements were read into the record, voices droned with cautious civility, and for a moment, it felt like just another performance in the long-running theater of American governance. Then, the questions began. Crockett, seated calmly with a thick binder in front of her and a quiet fire behind her eyes, asked the first question. Not with aggression, but with surgical clarity. She inquired about judicial accountability, about the court's refusal to adopt enforceable ethical guidelines, and whether that refusal eroded public trust. Chief Justice Roberts, clearly used to softer handling, responded with the smooth detachment of a veteran jurist. He offered carefully curated legalese, citing the separation of powers, the independence of the judiciary, and long-standing tradition. But Crockett was not moved by performance. She pressed deeper, asking whether tradition had ever been a sufficient excuse for opacity. Roberts, slightly tightening his tone, subtly shifted gears. He invoked constitutional language and suggested that Congress may not fully understand the nuance of judicial independence. He did not say Crockett's name with disdain, but the undertone was clear. This was a warning shot from the top bench in the land. A test. But Crockett didn't blink. She leaned in. Not physically, but intellectually. What followed next was not just a response. It was a demolition. She quoted Article 3 of the Constitution with ease, challenging Roberts' interpretation line by line. She referred to Marbury versus Madison, not as a historical name drop, but as a practical foundation for her argument about judicial review and the very mechanisms by which the judiciary holds power. She moved through the Federalist Papers as if she had co-authored them, invoking Hamilton's own arguments about checks and balances. When Roberts attempted to cite a lesser-known precedent from the 1940s, likely expecting it to stump a junior congresswoman, Crockett not only recognized it, she countered it with a more recent ruling that undermined his position. The courtroom, though not a courtroom in name, fell into silence. It was not the silence of respect. It was the silence of disbelief. The tension was now unmistakable. Here stood the Chief Justice of the United States, one of the most powerful legal minds in the country, essentially being cross-examined by a woman whose political career was still in its infancy. But it was no longer a freshman versus a veteran. This had become something else entirely, an ideological duel between a system that had long protected itself through complexity and a new generation that refused to be mystified by it. Roberts, sensing his usual tactics failing, attempted to reassert control by condescendingly reframing her questions. He used the language of institutional superiority. But Crockett was fluent in more than one dialect. She spoke the language of power, the language of the people, and the language of the law. And she fused them with a rhythm and logic that could not be unraveled. She referenced the Judicial Conduct and Disability Act of 1980, a statute long ignored by the court, and demonstrated how Congress had both the responsibility and authority to question judicial behavior. When Roberts claimed that judicial ethics were best handled internally, Crockett responded with the quote that would be replayed across the internet within minutes. "Ethics are not ethics if they're self-re."